Ball has already stated she wants nothing to do with it. She wants no entitlement to arrears. And before I infringe Mrs. Comrie negatively, I would think that I would allow her to offer to just close the case and disregard the $835.49, so that we don't turn this into something that it doesn't have to be.
Well, good luck with that. I've never seen the state give up any of their arrears. But so I'm looking, so she signed this in November of 2013. So the general procedure in a case like this, because it's not unusual to see people saying they want to close their case, is that they need to come to court and ask that a court order be entered to stop the child support. So we need to have Ms. Ball here rather than going on an affidavit. Do you have any contact with her?
No. But I would state that the affidavit in and of itself, although rebuttable with the testimony, and unless somebody's going to contradict the truthfulness of the affidavit, I would move the court, you to enter it into evidence, because it is in the clerk's record, and the clerk is the one who signed the affidavit. And if you can get that without objection, then I think we just put it into the evidence, and we can move on to really the foundational issue for the reason that the motion to contest driver's license should be granted and the case reversed as an operation of law.
All right. Ms. Comrie, any objection to Mr. Doss's Exhibit D being admitted into evidence?
And it's in the clerk's docket as well, Ms. Comrie.
It's Exhibit D to the
affidavit, no objection.
all right. All right, I'll mark the affidavit of fact signed by Ms. Ball and dated November 20th, 2013. And
Okay. And as to the $835.49, I'll just state in going to Feliciano versus Department of Revenue 305 SO3E 801 and 803, the improper calculation of a child support obligation amount pursuant to the child support guidelines, fundamental error that may be raised at any time, and I'll do it now. And because the original proceeding did not include myself or Ms. Ball, there is no competent substantial evidence upon which anyone, not only the hearing officer, who is, I have no issue with Ms. Cello, nor a judge, could have made a determination as to any amount. Furthermore, there's no affidavit in the record attached to that final judgment as well, and we can just go to Florida Family Law Rule of Procedure 12.285, subsection J, which demands the necessity of a child support guidelines worksheet, and I'll read it, and I believe everybody should have it because I submitted it with my filing as an exhibit. If the case involves child support, the party shall file with the court at or prior to a hearing to establish or modify child support, a child support guidelines worksheet in substantial conformity with Florida Family Law Rules of Procedure 12.902E. This requirement cannot be waived.
did you see the item that was filed on August 10th, 2004?
The final judgment, I believe, is attached to my filing.
Yeah, but the guideline is right there.
Who testified to the guideline?
I'm just saying, you said there is no guideline. I'm looking at the guideline.
In conformity with do you see the form 12.902E? Now we could all look it up.